Marbury v. Madison, 1803, 5 U.S. 137. To be honest, this case is so old, it is from when Pluto was still a planet. William Marbury, the plaintiff, was essentially appointed or commissioned into a cushy government job. Still unclear if there was actual work involved or if he just got a huge bag, but either way, he never got that government bag for being a judge or whatever, because James Madison was like, nah. To be honest, the whole thing was very petty. To be honest, the court was very wishy-washy on this case. SCOTUS, the Supreme Court, held, at least in theory, yes, it did agree with Marbury. What had happened was illegal. What they wouldn't do, which is what Marbury really wanted, was to offer a writ of mandibus. The court went so far as to strike down a law claiming it unconstitutionally granted a power to the SCOTUS which was not explicitly granted by the Constitution. They simultaneously granted a new power to the SCOTUS, one that was not explicitly granted in the Constitution, but this time it was okay. It is funny that the plaintiff and defendant in this case don't even crack the top 3 most important people in the case. All of this started because of ill will between John Adams and Thomas Jefferson. Jefferson had just defeated the incumbent President Adams, and Adams lashed out by appointing over 50 loyalist disruptors to various open positions in government, literally 2 days before Jefferson was supposed to take office, and many months after he lost the election. So this is where we get our first appearance, not the last, from Mr. Gold Bust on the 25-cent stamp himself, John Marshall. Marshall was John Adams' Secretary of State, basically was a lame duck seat until Jefferson took office, and he had already parlayed his Secretary of State job into a seat that was going to start with the new administration. He was going to become Chief Justice of the Supreme Court. So when Adams goes on this 11th hour appointing spree, John Marshall is the acting Secretary of State. He's tasked with completing the paperwork, basically. So Marshall begins to go through some of them, but he's trying to bounce to go join the Supreme Court. So he actually calls his brother, James Marshall, to come in for the very last 24 hours and take over finishing the paperwork. But apparently James Marshall did not finish some of the paperwork, and some of these appointments, including our plaintiff, the commissions were left for the new administration to complete, like a pile of papers on the desk. William Marbury was one of those midnight judges. At first, James Madison, he began to confirm some of the leftover appointments when he and Jefferson assumed power, since he was the Secretary of State for Jefferson. But then President Jefferson instructed Madison to ignore any unconfirmed appointments and told him he would personally appoint any vacant positions that did not get completed under Adams. The presidential election of 1800, Thomas Jefferson wins this election. John Adams appoints a bunch of people to various positions. 2 days before Jefferson is sworn in, Jefferson orders Madison. He doesn't specifically say don't confirm Marbury. He just says don't confirm anything that was left uncompleted. William Marbury sues for what he thinks he's entitled to. Almost 2 years after that, this is the biggest gap of time right here, from the time he files the lawsuit and the Supreme Court on February 24th of 1803 basically agrees, disagrees at the same time. But that's when they actually rule on the case. Key takeaways, these are self-explanatory, but when the Supreme Court cast their ruling, they created a new thing, and that thing is judicial review. So they just invented a judicial review, and then that power allows them to oversee both the legislative branch by saying, oh, nope, that law is unconstitutional or what have you, as well as giving instruction on how the executive branch should proceed in the execution or the acting, basically it oversees law enforcement and Congress. So it really establishes the foundation of that whole checks and balances sort of ideal. And it was not written in the Constitution. A little sidebar, another power was created also for the Supreme Court by this ruling, which allowed the Supreme Court to pick any case that it would like to hear and hear it. Prior to this, the only time it heard cases were when they went to another court and then it was appealed. But they just chose to hear this lawsuit, granted 2 years later. Thank you guys for following along. If you have any questions or comments about the video, definitely just leave them in the comments section. You know, creating this video here, it takes, time. Also, a lot of research that goes into it. Definitely more on the way, a lot of more content on the way. You can expect a lot more of these videos. Support the channel, obviously. If you want to support the channel, buy the merchandise. This is just the first video that I'm coming out with. There'll be plenty more on the way. Definitely be on the lookout. Buy my books when they come out. They're in the process right now. So anyways, thank you very much, and stay tuned. Just a couple, keeping my randomity here. A couple extra bonus points. For one thing, in the brutal mudslinging presidential election of 1800, also known as the Revolution of 1800, it was a lot of tension between the two parties and the two leaders of the two parties. So some of the accusations that were published was that if Jefferson became POTUS, then he was going to legalize prostitution and normalize incest. It was published that John Adams is a borderline hermaphrodite. I won't go into all the details of what was published. And then the next moving on from that, but the next was just this guy, John Marshall. He's one of the greatest swindlers of all time. John Marshall in this case, first of all, he was the one who should have done the whole thing was centered because he just neglected his position and bounced and left his brother involved to do it, to go join the Supreme Court. Then he comes back and they just cancel all the Supreme Court meetings for like 2 years. So then 2 years later, rather than recuse himself on something that clearly is like a conflict of interest, he could be argued he was criminally negligent in his duties. So he says, nah, I'm gonna rule on it. He says, hey, we're gonna strike down this random law, by the way. But because, you can't be just handing out powers. You can't just be handing out powers to the Supreme Court. Oh, by the way, in doing so, we're going to hand out this power to the Supreme Court in the name of keeping the power limited of the Supreme Court. The whole reason why all these 11th hour appointments were made was because they're trying to stick it to the other party. And then they lose the presidency, they lose Congress. But what do they gain? They gain control over the Supreme Court. And what do? They immediately say, oh, and by the way, I'm going to sit here and check all of you people from the Supreme Court. I'm not going to say this is the GOAT case, but in terms of this channel and everything that we're going to be reviewing case law, reviewing how court cases determine how police are allowed to act, how lawsuits are generated when someone's rights are infringed. Now, it didn't invent case law because even in the early justice system, we look back to other systems of government for inspiration. But, this is considered to be one of the all-time, most important, if not the most important court case. So figured we'd start with it. Hope you guys enjoy it. Let me know what you think and stay tuned.